Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss whether a decree obtained by fraud is a nullity or not. In the class, we discussed regarding that foreign judgment. Now, coming to the particular case, Honorable Justice B.R. Gawai and C.T. Ravikumar, in the case of Ram Kumar versus State of Uttar Pradesh in Civil Appeal number 4258 by 2022 on 28th September 2022 clearly observed that a judgment or decree obtained by fraud is equal to nullity. How this fraud occurred? Non-disclosure of the facts or non-disclosure of the relevant and material documents with a view to obtain the so-called decree or to obtain an undue advantage is fraud. So that fraud is equal to, now it is held nullity. Friends, previously in the classes while discussing section 13 of the CPC, I told you that according to section 13 subclause E, it is clear that if a foreign judgment is obtained by a fraud, it is nullity. It is not conclusive. But here, even though in India, if the judgment or if the decree is obtained by fraud, it is equal to nullity. It is void. Right. Now, coming to the facts of the particular case. Actually, this is a case relating to the cancelling of the license of a fair price shop or ration shop in Uttar Pradesh. Kiran Devi, actually, she was given a license for running the fair price shop in Anta Gram Panchayat of Kanpur district in Uttar Pradesh. So it's quite common that they will be receiving a lot of complaints against the fair price shop dealer because lot many problems will take place. They will do the mischievous acts also. We have to agree. Right. So various complaints were received by the revenue divisional officer, who is actually joint collector, is the competent authority regarding this so-called Essential Commodities Act. Under him, the RDO's work. So RDO, he has received number of complaints against the particular shop of the woman Kiran Devi. Ultimately, on 3/6/2017, the surprise check was conducted on the fair price shop by the vigilance department and also the revenue people. Ultimately, they noticed so many irregularities because the amount will not be tallied, the quantity will not be tallied, they will be having the so-called dead cards, so many things will be there. Since I worked in vigilance, I know all these tactics played by the so-called fair price shop dealers. Right. So they found certain irregularities, they have drafted the Panchnama, and ultimately, according to section 6A of the EC Act, so she was given the show cause notice on 7/6/2017 with the direction that she has to give the reply within 1 week. Of course, she did not give reply within 1 week later. That is on 16/8/2017, almost after 1 month, she has given her explanation. The explanation was taken into consideration, was not taken into consideration. Ultimately, the license was cancelled on 18/11/2017. Within 3 months, the entire thing happened. So the shop was seized on 3/6/2017 and the license was cancelled on 18/11/2017. Right. Now, later, this was allotted to Mr. Ram Kumar. He is the present appellant. Therefore, you have to read the case as Ram Kumar versus State of UP. This Ram Kumar, he was allotted the same fair price shop license on 27/2018, almost 8 months later. After the cancellation, 8 months have time taken. Why? Because the Tehsil Level Division Committee, they have appointed or they have recommended the name of Ram Kumar, basing on which he was duly appointed. This is the story so far happened. But Kamala Devi, or what is her name, Kiran Devi, who was aggrieved by all these things, by the conducting of inspection, all the cancelling her license. She approached the Honorable High Court of Allahabad and filed a writ petition. And the Allahabad High Court actually believed her version and came to the conclusion that the due procedure was not followed, and therefore once again the fair pay shop has been restored to Kiran Devi. Aggrieved by this, Ram Kumar, now he has filed the appeal before the Honorable Supreme Court of India. Right. The important point in this case is this Kiran Devi mentioned that, please remember, in her affidavit, that no third party arrangement has been made. Please remember, whereas here what happened in the year 2018 itself, yes, the shop was allotted, or the shop was granted to another person by name Ram Kumar. This matter was kept as secret, or it was not disclosed to the Honorable High Court. She stated that the fair price shop has been attached to another shop. Normally we do like that. RDO, when conducts inspection, if he finds that irregularities, he will actually seize the shop and ask the neighboring FP shop owner to continue the so-called ration to the beneficiaries. That work should not stop. So she stated that this was entrusted to another pet shop owner. But actually what happened? It was actually given, after due procedure, they have allotted the license to this Ram Kumar. That means this woman or the lawyer of that particular woman, they have hidden the facts. They wanted to do fraud. Suppose if it is mentioned that it is already allotted to another, court would have said already it is an administrative action, we can't help. So keeping that in view, they have played the fraud like this. So please remember, thus Devi not only suppressed the fact of allotment to Ram Kumar, but also tried to mislead the High Court. So please remember, it is fraud. So therefore, appeal is allowed, and appeal means who will file the appeal? Ram Kumar. So the appeal is allowed, and the order of High Court dated 21/12/2019 is quashed and set aside. So what you have to learn from this case is, please remember, do not try to play fraud on the court. So if you play fraud, definitely, even if not this step, in the next level of the court, definitely they will find it. That is what happened. So you should not take the courts granted that you can file whatever type of affidavit you like. Definitely there will be checks and balances, and court will not allow. So please read the judgment once again and enrich your legal knowledge. Thank you.